Hi, good evening, everyone. Welcome to the Prof Show. Tonight's show is called Delphi, the CHOMO, Details from the Public Court Record. And I want to welcome everyone in. We'll be getting started just shortly, so please make yourself comfortable, uh, sit down, be prepared to learn some things tonight, and I'll be seeing you in about 2 minutes. God bless.
Only need good vibes, good vibes, good vibes, good vibes. Only need good vibes, good vibes, good vibes, good vibes. Only need good vibes. Can't lie. Good vibes, good vibes, good vibes, good vibes. Been waiting so patient, I'm going places, can't fake it. My heart is so cold, my energy is contagious. All the pain, I can't take it. I'm staying grounded and graceful, cause I know everything that I've been through only made me count my blessings daily. Yeah, they've been acting shady, but I don't take it personal. The memories fading, I'm enjoying the moment. I've been smelling the roses, taking time to reflect, stepping back, the truth unfolding, unfolding. Got nothing to prove, cause I'm not the blow. I've been in the booth, speaking through my soul. You know that I'm true, either way it goes.
This stuff's coming to a close. There are more than one person involved with this case. It's not just Richard Allen. There's several others, and we've all seen them on TV and in interviews.
If your intentions are not pure, I can't let you get too close, cause I'm vibrating high. Ain't got time for your ego, these niggas quick to turn back. Acting like love me goes, we never cared in the shows. Wasn't with you at your lows, assuming that you wanna fold. But baby, I've been going ever since I let you go.
And I feel like
I've
it
been
tells
doing
us
better, and I
more
know
about
that
very
hurts to know.
than the people they're trying to degrade. They're
Only
always
good
trying to
vibes
degrade
around me,
someone.
and that's for sure. Me good vibes, good vibes, good vibes, good vibes. Only need good vibes, good vibes, good vibes, good vibes. Only need good vibes. Can't lie. Only need good vibes, good vibes, good vibes, good vibes. You see me searching for my inner peace. I've been learning more about myself and my purpose. You've always come to the surface, was hurting, but I had to heal, releasing all the pain that I always held. Been going through some changes, I'll make it still. Protecting my soul to keep it real. Only need good vibes, good vibes, good vibes, good vibes. Only need good vibes, good vibes, good vibes, good vibes. Only need good vibes. Can't lie.
I feel like it tells us more about
Good
the
vibes,
people they're trying to
good
degrade.
vibes,
They're always
good
trying to degrade someone.
vibes, yeah. Only good vibes, only good vibes.
All right, and welcome on in. I'm glad to see everyone. Hey, happy Wednesday, right? Today is Wednesday, April 8th, for those of you here on the live stream. And I'm good to see you on the live. And, hey, let's be honest here. The Delphi audience has dwindled down to nearly nothing. And so it's just been absolutely hellacious out here trying to keep this conversation going around this case, this obvious cover up by law enforcement of the murders of two little girls in Delphi, Indiana in 2017. So it's absolutely heartbreaking. Everyone has given up on this case, and it's insane, actually. But regardless, we're here. We're not going anywhere. And although it may be slow, we're going to keep working. And, we do have something to look forward to nearer the end of the month in a couple weeks. We will be anxiously awaiting the appellate attorneys for Richard Allen's reply to the state's reply to their appellate's brief. And so we will be waiting to try and take a deep look into what the appeal attorneys for Richard Allen have to say to this very thin state's argument regarding the appeal. And uh, there are just so many questions. And I was speaking with a friend this week about how this is insane with this case that people seem to be okay letting it go and forgetting about all of the 8 or 9 years of absolutely devastating and concerning information, most of which had leaked out from the local community. You know, I'm talking about the dozens and dozens of people out there at the trails that day those girls went missing, allegedly, all of the questionable statements from the family and other POIs in this case. Remember, there were guys like Garrett Kurtz, Chris Mathis, Keegan Klein, Tony Klein, Ron Logan, uh, uh, Julian Powell, and the list goes on and on and on. And so we want to reach out to the community and plead with you. Do not forget about the important things you've learned over the years because all of those important things still matter. For instance, the photoshopping in all of the supposed proof of life evidence of these girls, the very questionable bridge guy footage that exists that, remember, still has not been released to the public. We don't know what was shown in court and whether what was shown in court was actually from the girls' phones, fabricated or not. We don't know whether what these cranks have released out into this world is fabricated or not. We know that at one point in time, both Disney and NASA, and remember, this is back in 2017, 2018, 2019, when AI wasn't publicly available in the way that it is now, that both Disney and NASA worked on modifying this imagery or creating it, and there's a good reason to believe that's actually what's been released. What we've seen is Disney and NASA's creation. Uh, so it's just absolutely insane that with all of these things, people forget so easily. And I ask you not to forget so easily. Primarily because I believe that this case centers around child trafficking and a CI or informant for law enforcement induced incident. And what it appears to me is that this incident centers around a bunch of CIs in the state of Indiana. And yes, I mean individuals associated with or affiliated with the Venlanders, with the Outlaws, with the Hells Angels, with the meth traffickers, with the human traffickers, and all of these CIs necessarily being intimately directly tied to law enforcement, both on a local level, on a county level, and on a state level. That means Delphi Police Department CIs. That means Carroll County Sheriff's Department CIs. That means Lafayette Station of the Indiana State Police and Indiana State Police, Indianapolis-based CIs. Okay, if this is a CI centered incident, and there are a bunch of CIs out here in the world assisting law enforcement in the hiding of that fact and the protecting of the Dropbox and the potential connection to the human trafficking element or child trafficking, sex trafficking element, there's a lot to be concerned about. And I wonder if there is a parallel investigation or a tangent investigation uh, that breaks off from this that is the reason for this. But we really don't know what the reason is. All we know is that there is plenty of reason to believe that there are a bunch of CIs out here covering up for law enforcement in this case. And this case seems to be involving a bunch of CIs. Remember Derek German, right? Mike Patty, right? And all of the other CIs in this community affiliated with the gangs. And there's just a lot to be concerned about. And as we've been battling the struggle for the control of this public narrative by means of this tug of war between the local Indiana residents who all appear to be CIs. Oh, just a moment, please. Check, check. Check, check. Okay, I think we're good. Um, we've been battling this entire large contingent of individuals on the internet who have terrorized us, who have doxed us, who have defamed and slandered us. And it's interesting because this element or this contingent appears to be primarily made up of CI. So as we look out into this community operating online, attempting to uh, keep a stranglehold on this state's narrative and keep the public convinced of it, it really does appear that it's largely made up of CIs, this contingent. And there also appear to be a few feds or fed contractors involved, primarily those whom we call the PR team that goes by the uh, term of the cranks. These individuals appear to be law enforcement adjacent individuals on a federal, on a state, and on a local level. And like I said, in coordination with them, you have this group of local CIs. So it's been absolutely insane being out here trying to actually dissect this case and look into all of the nuances and the details of this case. And anyhow, with all of that being said, and all of the attacks and the smear campaigns and the personal attacks and the narrative control, we pay particular attention to the fine print when it comes to these individuals. And let's be honest here, there's no more anonymous individuals. Um, all of the ones who are hiding behind fake accounts and think that their identities are anonymous have been identified. We know who everyone is, okay? And all of these individuals are, as I mentioned, law enforcement adjacent. And typically I would not have a problem with that if they were out here doing good. But the fact that all of these people are out here harassing individuals, trying to control the narrative around this case, to keep public scrutiny and the online sleuths from looking into certain aspects of this case, in particular, the child sex trafficking and the gang affiliations, it's very interesting and concerning. And so we look at all of these law enforcement adjacent individuals and CIs, and we say, fuck off. We're not going to be putting up with this sort of harassment on behalf of the state. So that leads me to the point of tonight's show. We're going to be looking at a case that I've been following now for 2 years. Okay, and we're going to take a close look at this because I tell you, I've been it's been very difficult not to talk about this up until this point because I've been attempting to allow this scenario to play out before I really explored any of it with you guys. And it's been very difficult. Okay, it's been very difficult because you got to understand we're following these cases very closely. We're attending court hearings. We're getting court documents. We're keeping up with every aspect of this. And at the same time, as we're doing this, um, we're having to talk with individuals in the prison system. We're having to talk with individuals in the court system, with the uh, various clerks of court, with various attorneys. It's just been absolutely uh, all consuming trying to keep up with this information. And so, we tend to get pretty enthusiastic about bringing it. But I think now the time has come with this particular case to bring it to your attention because we've waited long enough. And anyway, we'll go back in time somewhat and kind of give you some context, and then show you what has surfaced in the meantime. And I think that the biggest takeaway that surfaces for me is the very reasonable assumption that we are dealing with this particular individual with a CI for the state of Indiana. Okay, and uh, and when you're considering that, you have to think about the behavior of this particular individual, because this particular individual has been behind a bunch of just appalling behavior, whether it be threatening the life of Richard Allen, whether it be accusing us of sex crimes against children, whether it be announcing hits out on Richard Allen, whether it be carrying firearms to the various legal proceedings in the case of Richard Allen, whether it be calling for the mass reporting of our channels and such. This individual has been quite problematic and been just a plague on the community. And and if this individual does turn out to be a confidential informant for the law enforcement of Indiana, uh, it calls into question the liability of law enforcement in Indiana for the behavior of their own CIs out here doing these sorts of things. And so this is the particular reason for our focus on this tonight. And before we get too far into it, I want to announce very clearly, so there's no confusion whatsoever, that we will be addressing public court records. Okay, so the things that you are going to see tonight are publicly available court records. There is absolutely nothing you will see tonight that is in any way confidential. There's nothing you're going to see tonight that contains any private information. There is no privacy being violated tonight. Okay, everything that you're going to see tonight is 100% public record, whether it be public court record or publicly posted on social media. We know that this individual in particular loves to claim privacy violations and fraudulently privacy strike anyone who dares mention this individual. Um, in effect, this individual has weaponized the privacy system on social media and has tried to censor everyone's speech using the reporting pathways, and has also tried to take down our channels. Okay, um, but that's not going to happen, and it hasn't happened. And honestly, if I were you watching tonight, I would recommend that you go ahead and download this immediately as soon as it's done, because there's a very high potential that this individual will attempt to remove this content within the next 24 hours, guaranteed. Um, but we're going to take you back in time somewhat. And I want to say that we're going to jump back all the way to October of 2024, more or less. I have a little difficult time remembering specifically exactly the date, um, but regardless, this in short goes back to 2024. This entire incident. Okay, and what happened in 2024 was that there's an individual out here on social media named Frank Wessling, who runs a true crime channel and has had several true crime channels over the years, and various of them have gone and come and the like. But Frank Wessling, uh, in 2024, stumbled onto this information in a couple different ways, primarily through background checks and the rumors on social media that had been persistent for years. Okay. And as Mr. Wessling was exploring this information, um, he had a friend reach out uh, to the proper authorities with some public records request. And that really started the ball rolling in 2024 with the disclosure of this information. And so I'm going to bring up some of those records for you so that you can be reminded of that. Okay. So this is This is a screenshot of a post by Mr. Frank Wessling regarding this particular incident, in which you can see that on March 23rd, 2024, uh, a request was submitted to the Marion County Clerk's office. Okay. And Mr. Wessling, through another individual, received a return on this public records request. And you can see here it says, "To whom it may concern, this correspondence is a response to your request for access to public records, which was received by this office on March 23rd, 2024. You specifically requested access to the following," and there's a number, and there's a name, Cursage, and I've redacted the first name of this individual. And there's a date of 3/01/2012. Class A felony decided: child molesting, child molesting, child molesting, intimidation. The documents you have requested have been marked confidential, can only be distributed to parties mentioned on the case. Should you have any questions, feel free to contact me at the Marion County Records. Tina Stevenson. Okay. And screenshot number 2 that he posted says, "To whom it may concern, this correspondence is a response to your request for access to public records, which was received by this office on March 23rd, 2024. You specifically requested access to the following report number." And again, it's Cursage, first name redacted, 8/27/2002. Class C felony decided: child molesting, which appears to be a typo. The following that has been requested has been marked confidential. This case can only be given to parties mentioned on the case with identification. Should you have any questions, please feel free to contact me at Marion County Records. Sincerely, Tina Stevenson, Marion County Clerk's Office. Okay? Now what I'm going to show you here, this is publicly available. Now this is on my case. So if you're interested in this, you can go to my case today, and what you do is you search Cursage v. Marion County Sheriff's Office, or just go ahead, search Cursage, case number 49C01 2408 CT 035284. It's in the Marion Circuit Court, and it's a civil tort type. File 806/2024. Okay. Defendant, Marion County Sheriff's Office, Kerry Forstall, the City of Indianapolis. Plaintiff, Cursage, redacted. And what I'm going to do really quickly, I'm going to show you the entire my case record. Check, check. Okay. Apologize for the audio issues. Here we go. We got, well, let me do this. Let me say, here we got subpoena summons filed, the City of Indianapolis, issue of summons, several of them all on 8/7/2024. You got a hearing scheduled activity. You got a video hearing information, status conference via WebEx or January 27th, 2025 scheduled. Um, Service returned, summons, appearance filed, notice of initial automatic enlargement of time to respond to plaintiff's complaint. You've got a Check, check, check. You've got a motion to dismiss filed by Marion County Sheriff's Office. You've got a memorandum of support of motion to dismiss. You've got a hearing set for motion to dismiss. You've got a plaintiff's response to motion to dismiss. You've got appearance filed for attorney in civil case for the city of Indianapolis, and order naming senior judge Cynthia Ayers. Okay, now we're going to take a look at the next page by October of 2024. Check. Okay, by October of 2024, there were motions to dismiss, order denying the motion to dismiss, motion to compel discovery filed by Kearsage, motion to compel discovery denied, status conferences, hearings. Okay, now here it gets very interesting here, and we're going to be going on into detail on this. But you can see here on February 3rd, 2025, there was a motion to seal public records filed. Okay, verified petition to exclude court records from public access. Okay, pursuant to ACR Rule 6, filed by Kearsage. Okay, then there was an order issued regarding that petition to exclude court records from public access. There were some hearings, some video hearings. The appearance filed of Barry F. McGinley for Marion County Sheriff's Office. There was an order denying the exclusion of court records from public access. As you see on February 24th, 2025, you had motion to expend dispositive motion deadline, motion to join motion to extend, joint defendants motion to extend, and motion for enlargement of time, emergency motion to extend time, and that was all granted. Then you can see there was a motion for summary judgment filed here on September 25th, 2025, motion for summary judgment by the Marion County Sheriff's Office, and a brief in support of said motion, okay? The city of Indianapolis files for motion of summary judgment, and a brief in support for motion of summary judgment. There's some more responses and whatnot in I would say that's October of 25. You see all of this happening. Okay, motion for discovery sanctions against the city of Indianapolis. Then you had a response to plaintiff's motion for sanctions, order denying, and then the appearance of Allison Reed for the Marion County Sheriff's Office. You had a motion to withdraw Carrie Forstall for Marion County Sheriff's Office, granting that withdrawal. You had a response filed the beginning of this year in January. Plaintiff's response to defendant's motions for summary judgment, plaintiff's cross motion for partial summary judgment as to issues of liability. Okay. Then a joint motion to strike plaintiff's motion of summary judgment. You had defendant's joint motion to stay or extend defendant's response deadline to Kearsage. Okay, an order granting said motion to strike, and a joint motion to withdraw hearing continuance by County Sheriff's Office for Marion County, and an order granting defendant's joint motion to withdraw February 10th, hearing continuance. And then finally, you had an order issued granting the Marion County Sheriff Office motion for extension of time and an order issued on the motion for summary judgment for all the defendants. Okay? So in other words, what it appears to me to be, and I'm no lawyer, it appears that on April 2nd, 2026, which is about a week ago, this case was put to rest in terms of the summary judgment was granted is what it appears. Okay? And you can see there's still a $232 court filing fee there. Now, so that's your brief history of the case. And as you could see, it started in approximately August of 24, I want to say, and it's brought us now to April of 26. This is how long we've been tracking this and how long we've been waiting to bring it to you, because we're going to get into some of the court record tonight. Again, remember, this is public court record. Okay, what we'll be reading tonight is public court record. We're going to be getting into some of the public court record, which is available on my case. As I said, you can go there now and download it all for yourself. Many of the documents are available in PDF format, so you can go over there and pull those documents for yourself and for your own perusal. If you want to possess those documents, I would highly recommend them. There's some informative reading. I should also note for you that I have meticulously gone in and redacted private information, although the court neglected to redact any of the private identifying information. I have personally gone in and meticulously redacted all personal identifying information so that all of you out there will not be exposed to any personally identifying information for Mr. Cursage here in this court record. However, if you were to go to my case and pull these documents yourself, you probably will be exposed to some personally identifying information regarding this case. So just a heads up there. Anyhow, what I've done for tonight is I've selected a handful of documents that give us the 30,000 foot view of this case, so that you yourselves can clearly understand what this case was about, what facts arose out of this attempt to sue the government of Indiana, and what details surface as a part of the fact finding and discovery of this. And I think this is highly concerning for our community here, especially if we're dealing with a community that is centering around the brutal murder and sexual exploitation of two little girls, 13 and 14 years old, in Indiana. And we're dealing with allegations of sexual crimes against minors. And we're also dealing with potential CIs involved in this. The question really remains for me is, what are people like this doing in this case? Okay? Anyhow, we're going to start here in October of 2025. Okay? So we're starting here in October of 2025 with the motion for summary judgment. It says, defendant, City of Indianapolis, files this motion for summary judgment as to plaintiff's claims. In support thereof, the City of Indianapolis states the following. Plaintiff's claims should be dismissed for the following reasons. The City of Indianapolis is not liable for the plaintiff's alleged claims, invasion of privacy, and intentional infliction of emotional distress, because it had no duty to redact the 2002 report based on the information in the expungement order, and because there was no breach by the city in that the Marion County Sheriff's Office not IMPD released such document. City of Indianapolis has an immunity under the Indiana Tort Claims Act because the city may not be held liable for the acts or omissions of a third party, and because the alleged disclosure, if somehow attributed to the city, was unintentional misrepresentation. Plaintiff's invasion of privacy claim must fail because the city did not make any disclosures. The information was not private in nature, the disclosure was not made to the public, and the information was of legitimate public concern. Plaintiff's claim of intentional infliction of emotional distress must fail, in that there is no evidence that the city engaged in extreme or outrageous conduct, or did such conduct recklessly or intentionally. And now we're going to look at the brief in support of the City of Indianapolis motion for summary judgment in response to Marion County Sheriff's Office motion for summary judgment. Defendant, City of Indianapolis, by counsel files this brief in support of motion for summary judgment for the purpose of judicial economy, incorporates a short response to co-defendant Marion County Sheriff's Office of Kerry Forrestal's motion for summary judgment. In support thereof, defendant City of Indianapolis states as follows. Introduction. The case stems from Marion County Sheriff's Office release of a 2002 arrest report in response to a public records request. Plaintiff alleges that the 2002 arrest report was ordered to be expunged and that releasing it violated the provisions of Indiana Code Section 353891, providing a basis for his claim of libel and intentional infliction of emotional distress. The root cause of plaintiff's allegation stems from deficiencies in plaintiff's own expungement order, which was inadequate to cover all the documents he apparently sought to expunge. Those deficiencies made it impossible for anyone, including the IMPD, to identify that the 2002 report related to any cases noted in the expungement order. Had plaintiff made a simple public records request under Indiana's Access to Public Records Act prior to petitioning for expungement, he would have learned that additional documents existed which were unconnected to plaintiff's specific criminal cases, allowing plaintiff to craft an adequate proposed order to ensure all law enforcement agencies were on notice of all documents which he sought to be expunged. Due to the insufficiencies of this expungement order, and because Marion County Sheriff's Office 2002 report bore no identifiable data points which could connect the 2002 report to cause number 49 GO40208 FC222318, the Indianapolis Metropolitan Police Department had no way to know that plaintiff wanted such document expunged. Furthermore, IMPD has no duty to expunge documents which are not covered by an adequate court order. Okay, so you got. Okay, so is that pretty clear so far? Is that pretty clear so far? So the documents that were not expunged were not requested to be expunged. That's the bottom line takeaway that I'm coming away with from this. All right. Now, furthermore, check. Okay. Now, let's get into the scenario. Now, this is going to get into the scenario. It says, in 2024, a rival true crime YouTube content creator sought information about cursage through a public records request sent to Marion County Sheriff's Office. After receiving such information, plaintiff's rival published it. Plaintiff now alleges, despite such loose causation, that the city of Indianapolis and IMPD are liable for failing to expunge the case report. Such a line of reasoning is faulty for several reasons. Plaintiff may not now, due to his or his counsel's insufficient attempt at expungement, attempt to hold the city of Indianapolis liable for a document which was not ordered to be expunged. IMPD has no duty to expunge documents outside the purview of a court's order, which would violate our APRA. Still, even if such expungement order should be constituted as attempting to cover a document like the 2002 report, determining that the 2002 report was covered by the expungement order was impossible at the time of expungement. The 2002 case report did not contain any information which IMPD or anyone could use to determine that it was connected to cause 222318. Furthermore, the Marion County Sheriff's Office was the entity that released such case report, not IMPD. Both entities are also immune from civil liability. Sorry, I had the mute button hit. Additionally, the Marion County Sheriff's Office and Kerry Forstall. Sorry, I had the mute button hit. Co-defendants in this case have filed a motion for summary judgment as to plaintiffs' claims against them. The city of Indianapolis does not disagree with much of their reasoning and agrees that the Indiana Tort Claims Act immunizes both Marion County Sheriff's Office and Forstall, and that the plaintiff has otherwise failed to state a claim for which relief may be granted. However, to the extent that the Marion County Sheriff's Office points to the city of Indianapolis and IMPD as a responsible party for expungement of such records, this argument misses crucial context. For instance, Marion County Sheriff's Office and Forstall failed to adequately address the inadequacy of the expungement order in this case, such that plaintiff's counsel failed to ensure that IMPD or any agency would be on notice that the 2002 report at issue was requested or ordered to be expunged. Furthermore, the Marion County Sheriff's Office and Forstall were on notice of the expungement order and so had the same obligation as IMPD to not release the expunged records. Crucially, the expungement statute in question was intended to prevent the release of expunged records, not to govern the form of expungements. Therefore, the city of Indianapolis and IMPD may not be held liable simply because the 2002 report, which was impossible to identify at the time of expungement and which was not released by IMPD, was in its custody and control. Okay. Now we're going to get to the juicy bits, okay? This says statement of undisputed material facts, okay? Undisputed material facts. Plaintiff Kersage was arrested on September 27th, 2002 by the Lawrence Police Department. On or about September 27th, 2002, Plaintiff Kersage was arrested by the Lawrence Police Department. The Lawrence Police Department assigned such incident the following agency case number, LPO 200003570. The arrest formed the basis for a criminal case against plaintiff in which he was charged with child molestation as a Class C felony in 49 GO4 0208 FC 222318. In November of 2002, the 2002 report was created by Marion County Sheriff's deputies regarding their arrest of Kersage. On November 7th, 2002, Kersage, apparently due to failure to appear or a violation of some type related to the underlying proceeding in cause number 222318, which is the child molestation Class C felony, was arrested by Marion County Sheriff's deputies. The Marion County Sheriff's deputies, or an employee at the Marion County Sheriff's Office, created the case report related to such arrest. The 2002 report did not contain any reference to cause 22238. Plaintiff's expungement order was faulty for failing to identify all documents and case numbers related to his request. Plaintiff, by counsel and pursuant to Indiana Code Section 353891, initiated an expungement proceeding under the cause number 49D312106XP019214 on July 9th, 2021. Now, I need you guys out there to put together the time frame in your minds. Why was this entire criminal history of this individual expunged in 2021? What else was happening in 2021? Okay, check, check. Now, then there are listed that there were 4 cases in which expungement was sought. Okay, and they list the cases there. You see, there are your 4 cases. Kersage claims in this case relate to his attempts to expunge documents related to criminal case number 49GO40208 FC222318. The expungement order found that Kersage was arrested in Marion County on September 27, 2002 by the Lawrence Police Department. The expungement order further found that the petitioner, which was charged with child molestation, a Class C felony, and that on March 27, 2003, all charges in that case filed against Kersage were dismissed. The expungement order pertained to all records related to criminal cause numbers but failed to include any case report numbers in such order. The following law enforcement agencies were notified of the requirements that documents associated with cause number 222318 were to be expunged: Indiana State Police, IMPD, the Marion County Sheriff's Department, and the Marion County Probation Department. IMPD fully complied with the court's expungement order as written, but could not identify documents which were unconnected to the case information provided in the expungement order and not otherwise specifically identified. Case reports are stored on the Law Enforcement Reports Program, which was developed and is maintained by IMPD. Documents in LEPR that are ordered to be expunged are marked as expunged by IMPD civilian employees, with some of those expungements occurring through the expungement program in LEPR. IMPD received the expungement order at some point in 2021 and began the process of redactions based upon the orders of the court. Amy Gibson, a civilian employee at IMPD, was tasked with marking documents to be expunged at the time. Before beginning the process of expungement for cause 222318, though Gibson made other expungements as is related to court orders concerning expungement of Kersage's criminal records, City of Indianapolis focuses on Gibson's expungement of records related to cause 222318 to prevent confusion. Gibson looked up the officer's 2002 report in IMPD's criminal. Did I miss a page? 5, 6. Oh no, I did miss a page. Is it out of order? Let me go get it. Apologize for that. Sorry, it's a lot of documents to get through here. Let's see. Okay, I'll just read it to you. Here we go. It says, let's see what this is called. Brief and support. Okay. Here we go. Page 6. I'll pull this down while I read page 6 since it's not relevant. Okay, page 6 states that Gibson looked up the officer's 2002 report in IMPD's criminal history system to determine the basic biographical information and to ascertain the agency case number associated with the cause. Because the underlying arrest in cause 222318 was performed by Lawrence Police Department, the agency case number Gibson located was LPO 200003570. Gibson used cause 222318 and LPO 203570 to locate all records in IMPD's database, which would need to be expunged. For LEPR, this included running the expungement program, which uses inputted agency case numbers and criminal case numbers to cross-reference all documents contained in LEPR and mark those documents as expunged. Gibson has no ability to expunge documents manually within LEPR and can only expunge a record within LEPR if it contains a matching agency case number or criminal case. To record the expungements which she made, Amy Gibson marked notations on IMPD's copy of the expungement order after she had expunged the certain categories of items related to cause 222318 and LPO 203570. In total, Gibson redacted the following categories of items related to cause 222318: officer arrest report, photos, and criminal history. That list of categories constituted all items which were connected to cause 222318 or LPO 203570. In LEPR and IMPD files, based upon Gibson's review of the order, this satisfied IMPD's obligation to redact the records which could be located as relating to cause 222318. At the time that IMPD received the expungement order, they were unable to determine that the 2002 report was in any way related to cause 222318 or LPO 203570 and could not have located such document pursuant to the information in that order. Furthermore, at the time IMPD received the expungement order, cause 222318 had already been expunged and removed from public records, making further investigation into the circumstances surrounding the criminal case impossible. Hold on. I got to do an oh my God. Cover your ears. It's going to be loud and annoying. Hold on.
Oh my God.
Bruh.
Bruh.
Let's read that again. Furthermore, at that time that the IMPD received the expungement order, cause 222318 had already been expunged and removed from public records, making further investigation into circumstances surrounding the criminal case impossible. Why? Why would that have already been expunged if they had not yet received the expungement order? Anyone out there got any guesses? Telling you. On March 24th, all right, on March 24th, 2024, the MSCO received a public records request from Monica Shanakas requesting any arrest reports, police reports, and case reports related to cursage. Rachel Gorman at as MCSO's paralegal, is responsible for processing public records requests for Marion County Sheriff's Office. On March 25th, 2025, Gorman emailed Shanakas 5 case reports that were responsive to her request. The 2002 report regarding an arrest of plaintiff in November of 2022 was included in these responses as it was not marked as expunged. Gorman testified at a deposition that she would have not released a 2002 report. So that was a typo. It should have said 2002. Report to Shanakas if it had been marked as expunged. Further, Ms. Gorman has sworn that the 2002 report did not have any court case number on it, tying it to any document that a court has ordered to be expunged. Okay? So we're going to take a moment now. We're going to jump to this defendant Marion County Sheriff's Office reply in support of motion to dismiss. You can see this is from October 2024. Okay? This says plaintiff Kersage concedes that he has not brought an action specifically relying on the violations of Indiana Code Section 353891 for the actions of the Marion County Sheriff's Office employee Rachel Goldman, who allegedly released law enforcement records improperly to a third party. Plaintiff's decision was wise because the Indiana Court of Appeals decision on Kerwood focuses on action based upon a violation of the expungement statutes. Despite Kerwood, plaintiff argues that he is still entitled to pursue two common law tort actions for the release of these law enforcement records. Kersage alleges that the release of such records amounted to an invasion of privacy by the public disclosure of private facts and an intentional infliction of emotional distress.
Bruh. I'm legally blind.
So sensitive, hurt fifis. Argument. Plaintiff's argument that Kerwood does not bar his claims is based upon a misunderstanding of that decision. Kersage's complaint alleges that Indiana's expungement statutes were violated by the defendants when an employee of the Marion County Sheriff's Office released to a third party certain criminal investigatory records that referred to Kersage's criminal activities. The information released was made confidential through the operation of Indiana's expungement statutes. That is, the plaintiff's allegation in this case is that in violation of the expungement statutes, a Marion County Sheriff's Office employee released certain law enforcement records, but plaintiff has conceded in his response that he cannot bring such a claim based upon the expungement statutes. Okay. Now, it goes into this Kerwood v. Elkhart County Sheriff's Department. And if you're interested in this piece of it, I suggest you go to my case and dive deeply into this, because they actually provide the entire Kerwood opinion. And so you can understand what this Kerwood is about. But just very briefly, it says, in support of that decision, defendants relied upon the recent decision from the Indiana Court of Appeals, Kerwood v. Elkhart County Sheriff's Department, which held that the expungement statutes do not create a private right of action. Plaintiff's response to the motion is to dismiss is premised on the following contention. What the Court of Appeals did not do that is critical in this particular case is that it did not affirm the grant of summary judgment based upon the lack of private right of action. That is to say that while the violation of the expungement is not a standalone claim, the facts surrounding such a violation can theoretically support a common law claim. Kerwood did not address that specific issue because the parties did not agree or argue it as confirmed by the brief filed by the defendants in Kerwood. Okay, and it recommends that you go see Exhibit A, which is attached, but we're going to skip over that. Okay. Okay. We're going to skip to Section B here. Marion County Sheriff's Office is immune from plaintiff's tort claim under the ITCA. Kersage's entire complaint is premised upon the violation of statutory right under Indiana Code Section 353891, and therefore his complaint should be dismissed because the expungement statutes do not create that right through a private right of action. However, even if the court believes the plaintiff's tort claims do not fall within the private right of action holding in Kerwood, the complaint should still be dismissed because Marion County Sheriff's Office is immune under the ITCA, which provides that a governmental entity or employee acting within the scope of the employee's employment is not liable of a loss results from the following. If a loss results from the following: the performance of discretionary function, whether an act is discretionary, is question of law for the court's determination. Okay. The Indiana Court of Appeals decision in Kerwood requires dismissal with prejudice because plaintiff's claims are derived from a violation of the Indiana expungement statute. As an additional reason, Marion County Sheriff's Office is immune from plaintiff's claims under the Indiana Tort Claims Act. Okay, so we're going to skip over this now. Now you'll see what happened next here in December of 2024. Okay. The next highlight in this case was this order denying the defendant Marion County Sheriff's Office motion to dismiss. It says this matter before the court on the defendant Marion County Sheriff's Office motion to dismiss plaintiff's complaint. The most relevant fact that forms the basis of plaintiff's complaint is that a Marion County Sheriff's Office employee improperly released plaintiff's criminal records that were previously made confidential by an expungement order issued by another court. The basis for defendant's motion to dismiss is defendant's argument that the Indiana's expungement statute does not create a private right of action for damages. Therefore, plaintiff's claims should be dismissed. In plaintiff's response to defendant's motion to dismiss, plaintiff argued that although the records were indeed made confidential by the operation of the expungement statute, his claims for invasion of privacy and intentional infliction of emotional distress are rooted not in the expungement statute. Oh my God.
Oh my God.
Bruh. Intentional infliction of emotional distress. Okay. Finding of facts. Years prior to the March 24th, 2024, various law enforcement records pertaining to cursage were ordered sealed by an Indiana court of competent jurisdiction. On or about March 24th, 2024, the Marion County Sheriff's Office, through an employee, released the previously sealed records to a third party. A tort claim notice was sent on behalf of cursage to the defendants on April 29th, 2024. So this guy, so within a month, this guy went get a lawyer. Okay, so he got his free, what do you call it? Veterans Administration lawyer or whatever. He got his free lawyer, okay, within weeks, probably immediately, within a week. He goes get his free lawyer to sue the sheriff's office, to sue the county and all of this for telling the truth about his CHOMO charges. Okay. But by April 29th, 2024, number 3 here, a tort claim notice was sent on behalf of cursage to the defendants. Plaintiff received no response from any defendant within 90 days of delivery. On August 6, 2024, plaintiff filed this action for damages, claiming that an employee, so in other words, August 6, he files this second action for damages, claiming that an employee of Marion County Sheriff's Office, Rachel Goldman, improperly released to a third party some of the records that were subject to expungement and should have been sealed pursuant to Indiana Code 353891. Plaintiff named the Marion County Sheriff Office, Sheriff Forstall, in his official capacity, and the city of Indianapolis as defendants. In other words, he thought he was going to get paid big. Plaintiff alleged that the torts of invasion of privacy and intentional infliction of emotional distress apply. Oh my God.
Oh my God.
Bruh. Okay, conclusion of law. Under Indiana Trial Rule 12b6, a complaint may be dismissed for failure to state a claim upon which relief may be granted. Accordingly, Trial Rule 12b6, motion to dismiss for failure to state a claim, tests the complaint's legal sufficiency. In testing legal sufficiency, the court is not testing the sufficiency of the facts alleged with regards to their adequacy to provide recovery, but the sufficiency with regards to whether or not they have stated some factual scenario in which a legally actionable injury has occurred. Trial courts should consider as true all the allegations of the complaint and should view a motion to dismiss in a light most favorable to the non-moving party. Okay. Anyway, we're going to skip ahead because this is going through the various motions about the that there are 4 elements which must be met to succeed on a claim of invasion of privacy. Number 1, that the information disclosed must be private in nature, that the disclosure must be made to the public, that disclosure must be one that would be highly offensive to a reasonable person, and that the information disclosed is not of legitimate public concern. A question, guys, is a true crimer in the being in the true crime community formally charged with multiple counts of child molestation? Is that of legitimate public concern? Just question for those in the back. You know what I mean? Bruh. Okay. Moving on to point number 2. The second cause of action plaintiff alleges is the intentional infliction of emotional distress. Okay. The Indiana Supreme Court held that upon satisfying the public disclosure torts elements, plaintiffs may recover emotional distress damages. I'm legally blind. The court finds that at the very least, plaintiff has pled 2 causes of action recognized and actionable under Indiana common law. Okay. The court denies the defendant's motion to dismiss. The court finds that the plaintiff has at least asserted a claim that is legally sufficient. Defendant also argue in its reply that this claim is barred due to sovereign immunity. The court finds this argument is premature and may be more appropriately determined at a summary judgment stage. For the foregoing reason, the court denies defendant's motion to dismiss. The court orders the parties may commence with discovery. And this is ordered December 3rd, 2024. Okay. Well, wouldn't you know it? Okay. Wouldn't you know it? Because this is a humdinger here. Okay. I got a humdinger for you guys. Just in case you're interested. This one is going to make you laugh. Right? You can see here that on February 24th, 2025, within 2 months of this, okay, the plaintiff filed a motion to prohibit public access, okay? Now, that's to keep us from seeing this shit, just so you know what this one means, okay? So this was an attempt now. I guess by February, it occurred to him that the internet was going to be concerned about this shit, right? So he files a motion to prohibit public access. Plaintiff's counsel indicated that he's a podcaster, YouTuber, and he has been getting harassed by people on the internet. You see? Plaintiff filed a motion to prohibit public access. Plaintiff's counsel indicated he is a podcaster, YouTuber, and has been getting, quote unquote, harassed by people online about allegations in this civil matter, as there are allegations that a prior charge for sexual misconduct was filed against the plaintiff.
Oh my God.
Okay. The court inquired if plaintiff has ever been threatened or suffered severe harassment that affected his life beside internet comments.
Bruh.
Boy, this judge is a trip. Aside from internet comments, have you ever been actually severely harassed or affected? Okay, the court inquired if the plaintiff has ever been threatened or suffered severe harassment that affected his life besides internet comments. Plaintiff indicated he has not. He also indicated the way the parties' words appear on filings can be or have been misinterpreted. It was a clerical error. No, that's misinterpreting. Oh, that girl lies. No, that's misinterpreting. The court denies the motion to prohibit public access at this time. The court surmises as a partial public figure, remember, limited purpose public figure matters here. As a partial public figure, a YouTuber, plaintiff opens himself up to public scrutiny to some extent. Again, as a partial public figure, a YouTuber, plaintiff opens himself up to public scrutiny to some extent. If the harassment increases to a point where plaintiff is in some legitimate fear for his safety, the court may reconsider. All right. You guys got that now? You guys got that shit now? Okay. It seemed like we're dealing with someone who can deal it out, but can't take it. A real shit talker, right? A real fucking shit talker.
Fuck you. Fuck you. Fuck you.
You can deal it out, but you can't take it. Emotional distress. Wait, let's go back. What was the other one? What was the other one? Hold on. Intentional infliction of emotional distress. Right? And what was the other one? What was the other one? Intentional infliction of emotional distress, harassment by people online. Okay. And it continues. Well, let me just read the bottom here. It says, the court previously ordered defendant to discover all of the Marion County Sheriff's Office employees' outgoing and incoming emails for 1 week post-incident. Originally, counsel for MCSO was only willing to provide emails that came up as a response to specific search terms. The court agrees a simple search term result could miss relevant emails. If defendant would not review all emails, the court then ordered defendant to produce all the employees' emails from that week. Defendant has now reviewed all 500 emails the employee sent or received the week after the incident. MCSO now objects to having to discover all of the week's worth of emails for relevance and cited Indiana Trial Rule 26, which states that a party is to discover evidence that is relevant or reasonably calculated to lead to relevant and admissible material. Defendant's counsel said it reviewed all 500 of the employees' emails for that week and produced all emails that are relevant or calculated to lead to any admissible evidence. In this case, the court read the rule on record and ordered, since defendant has now actually reviewed all of the emails and discovered the ones that are admissible or likely to lead to admissible evidence, defendant does not have to discover all of the emails, just the relevant ones. If the plaintiff still wishes for additional evidence, the court orders the plaintiff to meet with defendant outside of court and discuss the discovery issues further. Okay. The court leaves the October 2nd, 2025 status conference set. Okay. Okay, next. Now we're going to look at this declaration of Rachel Goldman. Okay, again, this is from September of 2025. Okay. Says, I, Rachel Goldman, have been duly sworn under oath, do hereby swear and affirm as follows. I am an adult over the age of 18 years old. I am competent to testify as to the matters stated herein. I have personal knowledge of all information in this declaration. I am a paralegal employed by the Marion County Sheriff's Office. In my role as a paralegal for the Marion County Sheriff's Office, I am responsible for reviewing and responding to access to public records requests submitted to Marion County Sheriff's Office. On March 24th, 2024, the Marion County Sheriff's Office received a public records request from Monica Shanakas requesting any arrest reports, police reports, and case reports related to cursage. On March 25th, 2025, I emailed Ms. Shanakas with 5 case reports that were responsive to Ms. Shanakas' request. One of the case reports, numbered 88750000 hereinafter report, was an arrest warrant report written by Marion County Sheriff's officers for the arrest of Cursage on November 7th, 2002 for child molestation.
Oh my God. Bruh.
Again, an arrest warrant report by Marion County Sheriff's Office for the arrest of Cursage on November 7th, 2002 for child molestation. Attached hereto as Exhibit A true and accurate copy. The report was not marked as expunged. If the report had been marked as expunged, I would have not released it to Ms. Shanakas. Further, the report did not have any court cause number on it. See Example A. All case reports, including the ones I pulled for Ms. Shanakas, are stored in the Law Enforcement Police Reports program that was developed and is maintained by the Indianapolis Metropolitan Police Department. Any report that is drafted by Marion County Sheriff's Office goes into the Law Enforcement Police Reports program. Below is a true and accurate direct screenshot when I clicked on the About button within the program. Marion County Sheriff's Office employees do not have the ability to mark as expunged within IMPD's program. Only the IMPD can mark case reports in the program as expunged. I was unaware of any expungement as to this report, but in an attempt to remedy the issue, I emailed Ms. Shanakas informing her that the reports were sent in error and that she should disregard them.
Bruh.
I don't think she disregarded them. I was also unaware of any YouTube channels or the alike by Cursage, Monica Shanakas, or Frank Wessling. I was informed by Cursage that Frank Wessling posted the information about the report on his YouTube. I was not aware that Monica Shanakas and or Frank Wessling were going to post any of the information from the report to YouTube. Bruh, you can't make this up. Oh my God.
Oh my God.
Drama. Okay. I affirm under the penalties for perjury that the foregoing representations are true. September 24, 2025. Okay. And here you go. Here's a report that she attaches. Okay. Marion County Sheriff for law enforcement use only, do not release. Case report, Exhibit A. Okay. Arrest on warrant. Location 2828 East 10th Street. Okay. Occurred November 7th, 2002. One injured. Okay, arrest. One injured. 0 dead, 0 vehicle. Oh, I'm sorry. Arrest 1. Injured 0, dead 0, vehicle towed 0. So arrest. Arrested. Cursage. Male. Age 33. 5'10", 215 pounds. Brown. Indianapolis, Indiana. Arrest date, November 7th, 2002. Arrest location, 2828 East 10th Street. Charge, child molestation, okay, probable cause, narrative. On the above date and time, the above subject was arrested on a warrant issued out of court G04 with no bond.
Bruh.
Okay.
Bruh.
Okay.
Bruh.
Okay. Is there any question about that? Okay. Arrest issued out on a warrant out of court G04 with no bond for child molest. Okay. Exhibit B. Findings in order granting petition for expungement of records of arrest, criminal charges, or juvenile delinquency allegations pursuant to IC 353891. Okay? Now, this is very important for you all. This is the actual expungement petition and order. Okay, so take a look at it. This is your expungement order. And it says here, Petitioner Cursage by counsel Trevor McSwain filed a verified petition for expungement of records of arrests, criminal charges, and the state of Indiana by counsel having filed its response to said petitioner. Petitioner's verified petition for expungement seeks relief for an arrest, criminal charge, or juvenile delinquency that did not result in a conviction. Upon review of said petition and the state of Indiana's response, the court finds that the state has found no legal basis upon which to state an objection to the court's granting of petitioner's verified petition for expungement and the sealing of records of criminal records. Now look at it. There's a date. There's related case numbers. You'll see at the top, there's 4 related criminal cause numbers. 49 GO5 1203 FA 13880, ISP arrest 3, ISP arrest 4, and 49 GO4 0208 FC 222318. And for some reason, there's been pinned in here LPO 2000857C. State of Indiana, County of Marion, in reference to the petition for expungement of records of arrest of Cursage, petitioner. Findings to all expungement matters. That petitioner's full name is redacted Cursage. That petitioner's date of birth is redacted. That petitioner's social security number is redacted. The petitioner's driver's license is redacted. Petitioner is a quote unquote honorably discharged veteran of the U.S. Army. How does that have anything to do with this? Can I ask for the idiots in the back? How does this have anything to do with CHOMO charges?
Bruh.
Number 6, that there are no charges currently pending against the petitioner, and petitioner is not currently participating in a pre-trial diversion program. Okay? Okay, I think I'm ready to read now. This is going to be a bit much, but keep in mind what we're going to look at now are the facts pertaining to the expungements of these 4 criminal charges. The records of these 4 criminal charges, okay, we're going to look at, and we have a lot of questions by this, so you guys should take notes. If you're not already taking notes, this is your time to take notes, because here's where you get the details from the public court record. If you look at the title of this live stream, I say you're going to get details. Here are your details. Okay, let's move on through them. Facts. Okay, facts pertaining to the expungement matter number 1, cause number ISP 49G05-1203 FA 13880. Petitioner was arrested in Marion County, okay, on or about March 4th, 2012. Okay, so here's March 4th. These are not in sequential order. I'm just giving you a heads up before we even get started. These are not in sequential order. So it's important if you're taking notes. These are not sequential.
I'm legally blind.
All right. On March 4th, 2012, Indianapolis Metropolitan Police Department. Arrest, Mr. Kersage. Action taken on arrest. Petitioner was charged under cause number ISP 49G05-1203 FA 13880 in Marion County, Indiana. And the following charges were filed. Count 1, child molestation, Class A felony. Do you guys know what a Class A felony is? Class A at that time was your highest level of felony. Okay, 30, 40 years. Class A felonies, now called level 1s. Okay, so this is a very strong charge in March 4th of 2012. Okay, let's continue. Count 1, child molestation, Class A felony. Disposition of case on January 17th, 2014. Okay. All charges filed against petitioner were dismissed by the
I'm
state.
legally blind.
Why were they dismissed? Petitioner's arrest, criminal charge, or juvenile delinquency allegation on or about March 4th, 2012 did not result in a conviction. At least 1 year has passed between the filing of this petition and either the date of arrest, the filing of criminal charges, or the date the appellate opinion vacating the conviction became final. The court now finds, as to expungement matter 1, the petitioner's verified petition for expungement shall be granted. Okay, now, expungement matter number 2, facts pertaining to expungement matter number 2. ISP arrest 0003. Petitioner was arrested in Marion County on or about August 1st, 2003 by the Marion County Sheriff Department. Action taken on arrest charges. Petitioner was charged under cause number ISP arrest 0003 in Marion County, Indiana on the following charges. Count 1, violation of probation. Again, though, look at this. Again, disposition of case on an unknown date. All charges filed against petitioner were dismissed by the state.
Bruh.
So here you go. Second dismissal by the state. Petitioner's arrest, criminal charges on August 1st, 2003 did not result in a conviction. At least 1 year has passed between the filing of this petition and the date of arrest, filing of criminal charges. Okay. The court now finds, as to expungement matter 2, cause number ISP arrest 003, that petitioner's verified petition for expungement shall be granted. All right. Facts pertaining to expungement matter 3. Okay, expungement matter number 3. Petitioner was arrested in Marion County on or about November 18th, 2002 by the Indianapolis Police Department. Action taken on arrest charges. Petitioner was charged under cause number ISP arrest 004 in Marion County, Indiana, and the following charges were filed. criminal recklessness. And again, on an unknown date, all charges filed against petitioner were dismissed by the state.
Oh my God!
Bruh. Petitioner's arrest, criminal charges on or about November 18, 2002 did not result in conviction. At least 1 year has passed between the filing of this petition and the date of arrest, filing of criminal charges. And the court now finds, as to expungement matter number 3, cause number ISP arrest 004, that petitioner's verified petition for expungement shall be granted. Okay, and now facts pertaining to expungement matter 4. Petitioner was arrested in Marion County on or about September 27th, 2002 by the Lawrence Police Department. Action taken on arrest charges. That petitioner was charged under cause number ISP 49G040208 FC 222318 in Marion County, Indiana, and the following charges were filed. Count 1, child molestation. This time a Class C felony. Class C. Again, disposition of this case on March 27th, 2003. All charges filed against this petitioner were dismissed by the state again.
Bruh.
Again, this is your 4th dismissal of charges in a 10-year period. Petitioner's arrest, criminal charges on or about September 27, 2002 did not result in a conviction. At least 1 year has passed between the date of the filing of this petition and the date of arrest or filing of criminal charges, and the court now finds to expungement matter number 4, cause number ISP 49G040208 FC 222318, that petitioner's verified petition for expungement shall be granted. Ordered. It is therefore ordered, adjudged, and decreed that petitioner's verified petition for expungement of records of arrest, criminal charges, or juvenile delinquency allegations shall be granted to all expungement matters pertaining to all records relating to criminal cause numbers ISP 49G05-1203 FA 13880, ISP arrest 003, ISP arrest 004, and ISP 49G040208 FC 222318 as to all expungement matters on which expungement is granted as required under IC 35389 IG, all information necessary to identify particular agency records that are to be expunged pursuant to this order has been included in the Exhibit A attached and incorporated into this order. All information placed or retained in any state central repository for criminal history information or any other alphabetically arranged criminal history information system maintained by local, regional, or statewide law enforcement agency shall be removed by the following agencies. Okay, and check this out. Indiana State Police, Indianapolis Metropolitan Police Department, Marion County Sheriff's Department, and Marion County Probation Department. ISP, IMPD, Marion County Sheriff's, Marion County Probation. The records of the sentencing court, the Indiana Court of Appeals, and Court of Supreme Court concerning this person shall be redacted or permanently sealed. Permanently sealed.
Bruh.
Nothing in this order shall be construed to prevent the Indiana Bureau of Motor Vehicles from reporting information about a conviction for a violation of traffic control law to the Commercial Driver's License Information System. Okay, so ordered this day of July 9th, 2021. So like I said, What was happening in 2021? What was happening in 2021? Things were being set in motion for the arrest of Richard Allen, right? Remember when I've said to you about the cranks, that all of the cranks were getting pre-positioned. All of the troll farm YouTubers were getting pre-positioned. In the year or two, say between 2019, when the change of direction occurred, and 2022, in those 2 years, in those 2 or 3 years, everybody was getting positioned to be the authoritative voices throughout social media on the Delphi case, whether it's on Reddit, on Twitter, on YouTube. All of these individuals were being pre-positioned. Okay? That's what was going on in 2021 when this expungement of 10 years worth of charges. And like I said, what are the odds that you'd have a criminal with 4 arrests for criminal charges and all of them be dropped by the state? Now let's go back to this here where we left off before. It says plaintiff's competitors weaponized the information released by Marion County Sheriff's Office. Plaintiff has a channel on youtube.com where he posts true crime content. Frank Wesseling, an apparent rival or contemporary of plaintiff, also operated a YouTube channel related to true crime. Shanakas was an associate of Wesseling. None of this information was known to Gorman at the time of Shanakas' public records request, nor was she aware that Shanakas or anyone else who might receive the information from Shanakas might publish any of the information related to the 2002 report. Shortly after the public records request was fulfilled, Wesseling posted the information related to the 2002 report. And that's what I showed you at the beginning. So let's bring that, I want to bring that back in. Where was it? Again, remember when I said that this was posted, right? Let's see. This here. This is Wesseling's post regarding this public records request from Marion County Sheriff's Office. Okay, so 9 of the 10 commenters with the fancy true crime names have no idea for the reason I did what I did. I'd rather take the blame and let the system work out instead of so-called true crime channel that might as well write fiction books for the crap they say without evidence. Instead, ask yourself how someone who had 2 confidential child molestation charges got the images, meaning the crime scene images. Okay. Kersage claims, shortly after the public records request, Wesseling posted the information on a YouTube community page referencing the fact that it related to child molestation charges. Kersage claims to have been harassed by members of the public as a result. Oh my God.
Oh my God.
Kersage then informed Gorman that the 2002 report should not have been released as he believed it should have been expunged. Gorman was not aware of any expungement having been related to this report, but attempted to remedy the issue by emailing Shanakas and informing her that the reports were sent in error and that they should be disregarded. Standard of review. The purpose of summary judgment is to terminate litigation about which there can be no material factual dispute and which can be resolved as a matter of law. Summary judgment is appropriate if the designated evidentiary matter shows that there is no genuine issue as to any material fact and that the moving party is entitled to a judgment as a matter of law. A fact is material if its resolution would affect the outcome of the case, and an issue is genuine if the trier of fact is required to resolve the parties' differing accounts of the truth, or if the undisputed material facts support conflicting reasonable inferences. Once the moving party satisfies that burden, the non-moving party may not rest on its pleadings, but must designate specific facts demonstrating the existence of genuine issue for trial. Argument. Plaintiff's complaint alleges that the city of Indianapolis committed the torts of invasion of privacy and intentional infliction of emotional distress due to its actions.
Oh my God!
Bruh.
Bruh.
Okay. And now we're going to move. Okay, we're going to skip ahead and jump into this one, which is your order granting defendant's motion for summary judgment. Okay, now this is filed April 2nd, 2026. Remember I said this was days ago, about a week ago, in which the Marion County Sheriff's Office, Kerry Forstall, in the city of Indianapolis filed for this motion for summary judgment. Okay. So let's read this one. It says, order granting defendant's motions for summary judgment. This matter is before the court on defendants Kerry Forstall and Marion County Sheriff's Office, collectively it should be MCSO's defendants motion for summary judgment filed September 25th, 2025, and defendant City of Indianapolis's motion for summary judgment filed October 2nd, 2025. Plaintiff Kersage filed his response to defendant's motions for summary judgment on January 8th, 2026. The court conducted a hearing concerning the motions for summary judgment on February 10th, 2026, where all parties were present in person and gave oral argument. The court, having considered the parties' filings, designated evidence, oral arguments, and being duly advised, now finds and concludes as follows. In September 2002, plaintiff Kersage was arrested by the Lawrence Police Department. That arrest was assigned agency case number LPO 200003570 and formed the basis for criminal cause number 49GO40208FC 222318. Cause number 222318. In cause number 222318, plaintiff was charged with child molestation, a Class C felony.
Bruh. I'm legally blind.
On November 7th, 2002, plaintiff was arrested on a warrant by deputies of the Marion County Sheriff's Office. The basis of this arrest by MCSO was that plaintiff violated his release conditions that were a condition of his release to cause number 222318. Oh my God. Do you guys realize what that means? Okay, because we have to infer. Remember, we're not getting all of this detailed information because all of this has been expunged. We can't go back and look at all this shit. Okay, but what this says to us is that as a result of this arrest for child molestation, defendant Kersage violated the terms of his probation and was very quickly arrested thereafter. So let's look at that again. So hold on. Go back to the dates, okay? In September of 2002, Kersage was arrested by Lawrence PD, charged with child molestation Class C, okay? September 2002. On November 7th, 2002, he was arrested on a warrant by Marion County Sheriff's Office for violating the release conditions to the September 2002 arrest for child molestation. So, in other words, he didn't even make it 2 months. Less than 2 months later, he's arrested for violating the probation for the child molest arrest. Is that making sense? If you're writing this down? Now, on to number 6 here. It says a report was generated in connection with the arrest made by Marion County Sheriff, the 2002 report. Although there is a place on the officer arrest report where an arresting officer could write a related cause number, the 2002 arrest report created by the Marion County Sheriff did not include any reference to the related cause number, 49 GO4 0208 FC 222318. Law Enforcement Police Reports Program is the electronic repository system used to store case reports and related law enforcement documents for the agencies at issue. We learned about that earlier. LEPR indexing and search functionality rely on fields such as agency case number and criminal cause number to associate reports within a given criminal case. The LEPR is maintained by the IMPD, Indianapolis Metropolitan Police Department. In or around 2007, the IMPD, Indianapolis Police Department, and the County Police Division of MCSO, Marion County Sheriff's Office, merged to form IMPD, which became the successor entity for the purposes of records management. In 2021, plaintiff filed a petition for expungement under cause number 49D312106 XP 019214, seeking an expungement of records related to multiple cases, including the initial case number, which was 222318. Okay? So again, in 2021, he files for expungement of these 4 arrests. You understand what I'm saying?
Bruh.
On July 9th, 2021, this court in the expungement cause 019214 entered an order, the expungement order, which we just read, directing the expungement of records related to specific cause numbers, including an order to expunge all records related to cause number 222318, which was the first arrest for child molest, okay, in 2002. The order identified cause by cause number and did not identify specific arrest report numbers. The expungement order was transmitted to relevant agencies, including the IMPD and Marion County Sheriff's Office. The IMPD personnel undertook efforts to identify and mark records subject to the expungement order within this LEPR program. This process relied on matching cause number and agency case number to records contained in the system. Using cause number 222318 and agency case number LPO 2000-3570, IMPD identified and marked certain records as expunged, including an officer arrest report, photographs, and criminal history entries associated with those identifiers. The 2002 report created by the Marion County Sheriff for cursage, violating his release conditions. Again, remember I said within 2 months he violated his release conditions for the child molest arrest.
Oh my God.
Bruh. For violating his release conditions, this report was not identified during the expungement process because it did not contain a reference to cause number ending in 222318 or LPO 2000-3570 within the LEPR program. As a result, the 2002 report was not marked as expunged following entry of this expungement order. Marion County Sheriff Office contends MCSO personnel did not have the ability to independently mark reports as expunged within the LEPR system. that function is performed by Indianapolis Metro PD or IMPD. Again, on March 24th, 2024, Marion County Sheriff's Office received the public records request seeking records relating to the plaintiff. And that was the one from Monica Shanakas on behalf of Frank Wessling. On or about March 25th, 2024, Marion County Sheriff's Office employee Rachel Goldman responded to the request by producing several reports, including the 2002 report. At that time, Ms. Gorman was working in her capacity as a civilian employee of the Marion County Sheriff's Office. When the public records request for cursage was fulfilled, the 2002 report was not marked as expunged in LAPR and did not contain any reference to the cause number linking it to any expunged case. As a result, Ms. Goldman released the 2002 report. Ms. Goldman has testified that she would not have released the 2002 report had it been marked as expunged. After its release, the 2002 report was disseminated publicly online by a third party, Mr. Frank Wessling. Said third party has no relations to IMPD or the Marion County Sheriff's Office. Plaintiff subsequently asserted that the 2002 report should have been treated as expunged and not released. Following notification from the plaintiff, MCSO personnel contacted the recipient of the records and indicated the 2002 report had been released in error. Can't make this shit up. Bruh. So you guys understand yet the full picture of these this entire sequence of events? Because I do have a conclusion here, which I guess I'll say it now. The ultimate conclusion is, would it not be for the error from law enforcement in filling in the single field in that 2002 arrest report for violation of the conditions of the probation related to the child molest charge and arrest? If it were not for the error in law enforcement's bookkeeping in filling out that field, none of this would be known to any of you. Okay? None of us would know anything about all of this except for the word on the street, which we know the rumors had been floating around for years prior to 2024 when all of this transpired. But were it not for law enforcement making this mistake in the record keeping, and Mr. Wessling through Miss Monica Shanakas requesting reports related to Mr. Cursage, none of you and none of us out here would know that you have an individual in this true crime community who has been very combative and very fixated on smearing and slandering several of us out here advocating for the truth of these crimes. None of us would know that there are these skeletons in his closet. Okay? Neither would we know that you have an individual with a lengthy criminal history in which the DA or the state every single time has dismissed his criminal charges. Okay? Is this smelling like a CI for the state of Indiana to you yet? Okay. Conclusions of law, summary judgment standard. Summary judgment is appropriate when the designated evidence shows that there is no genuine issue as to any material fact and the moving party is entitled to judgment as a matter of law. Once the moving party satisfies that burden, the non-moving party may not rest on the pleadings, but must designate specific facts showing the existence of a genuine issue for trial. Plaintiff's negligence theory fails as a matter of law. Indiana's expungement chapter requires a court, when an expungement petition is granted, to order that no information concerning the arrest be retained in the law enforcement criminal history information system, but the chapter does not require any change or alteration in non-public internal law enforcement records made at the time of the arrest and not intended for public release. The colloquial understanding of the expungement statute requires a law enforcement agency and or court not to release records relating to someone's criminal history that have been expunged. This prohibition applies to the actual case, and depending on the language of the order, any related and or tangentially related reports, convictions, probable cause affidavits, etc. In the case at hand, per the common understanding of the expungement statute, law enforcement would have been required to not release any documents related to the cause ending in 222318 or any related documents that referenced that cause. Pursuant to the affidavit of Rachel Goman, she did comply with the statute in that she ensured not to release any documents that to her knowledge were related to cause ending in number 222318. Based on the designated evidence, the court notes that the 2002 MCSO or Marion County Sheriff's Office arrest report that involved a violation of the pretrial conditions, violation of your pretrial conditions, was not linked to LEPR or in LEPR to cause number 49 GO4 0208 FC 222318. This was not intentional. There was not a link because the officer who filled out the arrest report in 2002 did not place any reference to the cause number ending in 222318 on that arrest report. Because of the failure to list that related cause number, there was no link in LEPR between the 2002 Marion County Sheriff's Office arrest report and the expunged cause ending in 222318. Marion County Sheriff's Office and the City of Indianapolis argue that Goman had no independent ability to mark records as expunged within the LEPR system. Plaintiff has brought a claim that Goman's actions constitute negligence. To prevail on a claim of negligence, the plaintiff must show 1, duty owed to the plaintiff by the defendant, 2, breach of duty by allowing conduct to fall below the applicable standard of care, and 3, compensable injury proximately caused by the defendant's breach of duty. Absent a breach of duty, there can be no negligence or liability based upon the breach. The court must determine if the expungement statute creates a duty. As written Indiana Code Section 3538(9) 1HI does not explicitly establish a duty for governmental agencies to ensure that no documents tangentially related to an arrest, criminal charges, and or vacated conviction are not disclosed. The statute merely requires that no information concerning the arrest, criminal charges, or vacated conviction be placed or retained in any state central repository for criminal history information. Since the statute creates no duty, there can be no breach. And remember, this is the court's order here. The court does not find Goman and or Marion County Sheriff's Office has had a duty based on these facts and the applicable statute. However, even if one believes a duty does exist, plaintiff's claim for negligence still fails. Ms. Goman was an employee of a government agency working in her official capacity as an employee of the Marion County Sheriff's Office, fulfilling a work duty when she disclosed the arrest report. As discussed below, the applicable government agencies, Marion County Sheriff's Office and City, are immune. Defendants are immune under the Indiana Tort Claims Act. The Indiana Tort Claims Act immunizes a governmental entity from losses resulting from misrepresentation if unintentional. Unintentional. That's the key term there. Indiana courts construe that immunity to bar claims arising out of negligent communication of incorrect information precludes recovery for claims against the state arising out of a negligent misrepresentation, which includes the negligent conduct of the government in obtaining and communicating the information. The designated evidence shows that at most the release of the 2002 report reflected an unintentional failure to recognize that the report had not been linked to the expunged cause number NLEPR. The plaintiff's tort theories therefore fall within the ITCA. The ITCA provides immunity for unintentional misrepresentations. The defendants, Marion County Sheriff's Office and the City of Indianapolis, are both government agencies. Their employee did not intentionally produce the 2002 report. Therefore, defendants Marion County Sheriff's Office and the city are entitled to immunity on that basis. Now, number 4, plaintiff's invasion of privacy claim fails. Invasion of privacy.
Oh my God!
Excuse me. Does anyone have privacy to be a child molester? Indiana recognizes a tort claim for public disclosure of private facts, and a plaintiff must prove that the information disclosed was private in nature. The disclosure was made to be public. The disclosure would be highly offensive to a reasonable person, and the information was not of legitimate public concern. Plaintiff cannot satisfy the publicity element because Marion County Sheriff's Office released a report to a single requester, and a communication to one person does not amount to publication to the public or to a large enough audience to make the matter public knowledge. Plaintiff's invasion of privacy claim therefore fails as a matter of law against both defendants. Now, Part 5, plaintiff's intentional infliction of emotional distress claim fails. To recover for intentional infliction of emotional distress, a plaintiff must show extreme and outrageous conduct that intentionally or recklessly causes severe emotional distress, and Indiana courts have repeatedly emphasized the standard is rigorous. The mistaken release of a report that had not been identified as expunged does not rise to the level of conduct that is atrocious or utterly intolerable in a civilized community. But you know what is utterly intolerable in a civilized community? And you know what is atrocious? It's touching children, bro. Touching children. Indeed, this is not a case in which the recitation of facts to an average member of the community would arouse his resentment against the actor and lead him to exclaim, outrageous, because the plaintiff has not shown the predicate tortious conduct or the degree of culpability required for the IIED, intentional infliction of emotional distress. That claim also fails as a matter of law. Conclusion. Based upon the foregoing, the court finds that there are no genuine issues of material fact, and defendants are entitled to judgment as a matter of law on all claims. It is therefore ordered that defendants Kerry Forstall and the Marion County Sheriff's Office motion for summary judgment and defendant City of Indianapolis's motion for summary judgment are granted. And that's ordered on April 2nd, 2026, just a week ago, by Amber Collins, judge at Marion County Circuit Court.
Bruh.
So in terms of just a moment, let's see. Wonder if I got something wrong here. All right, so sorry about that. So in terms of all of that, which, as I mentioned, let me show you again, is on my case. If you're desiring to see any of this for yourselves, okay, Kersage v. Marion County Sheriff's Office, case number 49 CO1 2408 CT 035284, filed 8/6/2024. Okay. There is so much more on my case that you can go ahead and download. For instance, there's depositions of these involved individuals who were employees. There's a lot more information, but this is the in brief. Okay, this is the brief. This is in a nutshell this case. Now, as I mentioned, I find it very interesting that this guy has been such a cancer on this community, has been as hateful, as combative, as narrative steering, as clout chasing, as unified command ball licking, and Patty family shilling as he is. Again, this is the guy who claims to speak on behalf of Becky Patty. Remember, this is the guy who has consistently gone out there and claims that he represents the Patty family. Why is the Patty family having a representative speak for them with this kind of criminal history, regardless if it's expunged or not? It sounds to me like this is a CI. Remember when I said initially, this case is plagued by CIs. It almost seems like this is a case that involved a bunch of CIs and some girls got dead. All right. And so now you have all the CIs and law enforcement covering the case up because this leads to negligence on the part of law enforcement in which a whole bunch of CIs got some girls dead. Law enforcement wants to wash their hands of the whole issue. So they've gone and created this whole debacle over all these years, okay, which nothing has made sense coming from law enforcement from day one, okay? And it appears that they've gone found this guy, right? Wrongly convicted him with fabricated evidence to try to bury this whole thing. And you still got CIs out here trying to control the narrative on this case and a whole PR team working on behalf of the state of Indiana. So what the hell is this? All right. And just to refresh some of your memories, because I know a lot of people don't remember everything we've been through, but remember I've shown you this guy has repeatedly attempted to speak on behalf of Mike and Becky Patty. And not only that, he's been seen and overheard being thanked and congratulated by the Pattys for his work and his efforts and proving his worth, quote unquote. And let's remind ourselves of all the death threats, the announcement of hits, the various things this guy has done, right? Remember, these are a few of the announcement of hits on Richard Allen prior to his conviction or sentencing. Yeah, everybody, he's in protective custody. He ain't going to Gen Pop because I never told you. I got a message from somebody that knows somebody that was in Wabash Valley, and they were telling me that there was a hit out on Richard. Okay, this was a guy announcing a hit. This very guy we've been discussing. Okay, not just at Wabash Valley, but he says, you know, Pendleton is getting rough, and if it's anything what people are telling me, he's not going to make it. And I hate to say that, you know, I've got my opinions on how I feel about Richard Allen, and that's not my place to put it out there. But y'all know how I feel in my position on something happening to him at Pendleton. This is what I would do. Turn a blind eye to it because he deserves every last bit of whatever he's got coming to him. Oh, trust me, karma's still knocking. Okay, and that is what he says after announcing the hit on Richard Allen. He also said, well, he's in Pendleton. My buddy calls me and says, man, you know that motherfucker Richard Allen's causing a bunch of ruckus up there in fucking West Pendleton, and they've locked down the whole bunch of blocks up there because of him. So I can't talk to my son or nothing. Now he's not in Gen Pop. No, he's in PC, protective custody. So he's checked in. Yep. He doesn't get that automatically. They checked him in PC because I've been told is things that people are running past me, you know, that in Pendleton and that down in Wabash, there was people down there that were contracted to do something to him down there.
Bruh.
He also says, I told Becky about Noe making claims that I did a live saying Becky had hired me to get Richard Allen killed. I about blew a gasket and she just started laughing, you know, and she said, I understood what you said, but she said, I don't want him killed just yet. I want him to suffer a little while. And that's Becky Patty, according to this dude.
Oh my God.
And, you know, I'll remind you that this guy was also at the trial of Richard Allen carrying a firearm, threatening that Richard Allen was going to get killed regardless. Okay. And this is him back in 2023 saying that at some of the hearings, he had his firearm with him. Okay. And here he's posting his 40 caliber Smith & Wesson firearm. Remember, the firearms down there at Delphi that were identified as potentially the class of firearms making those extraction marks were both Smith & Wesson and Sig Sauer 40 calibers. They had narrowed it down to Smith & Wesson 40 calibers. Well, oddly enough, this dude here has a 40 caliber Smith & Wesson that he flashes right along with his marijuana possession. Keep in mind that people are regularly every day arrested for marijuana possession in Indiana, which marijuana is still highly illegal. So here's you got this guy not only in possession of marijuana, but possession of marijuana with a firearm. Okay. Okay. This is all 2023, carrying his firearm to the hearings and to the trial, right? Speaking as the official spokesperson for the Patty family. Okay. So what is this expungement anyway of such disgusting charges? So I looked into it. Indiana has something called the second chance law, which was recently signed several years ago into effect. The second chance law. Okay, second chance law. Now, in my opinion here, this is absolutely unacceptable. Okay. If there was probable cause to arrest twice for child molestation, do you think that that should be up for expungement in the state of Indiana? So this is from the Marion County Clerk's Office, okay? Indy.gov, second chance law. How to file an expungement petition. Complete the petition. Bring your original petition to the Marion County Clerk's Office, okay? Though the petition concerns criminal matters, it will be given a civil case cause number. Petitions will be assigned to the original trial court. Clerk staff will take the original, provide you with one copy of the petition. Court staff will notify you of any hearing and whether or not your petition is granted. Help filing your petition. For assistance filing your petition, you can reach out to any of the following organizations. Okay, Neighborhood Christian Legal Clinic, Indiana Legal Services, Indianapolis Legal Aid Society. Clerk's office staff can process expungement petitions all week during business hours. For those petitions with multiple criminal cases listed, like this one, The civil case will be assigned to the court that handled the criminal case with the highest offense. What was the highest offense? Remember, the Class A felony, which is now considered a level 1, the child molest 2012 Class A level 1. For petitions where the criminal cases are of the same level of the offenses, the petition will be assigned the court handling the most recent. For those petitions where no charges were filed or the case dismissed, the petition will be reviewed by the court it was originally filed in. If no court was assigned, it will be randomly assigned a court of the appropriate charge level. Separate petitions should be filed for each case where no charges were filed or the case was dismissed. Note, there is no filing fee required for these types of cases. About expungement petitions, you may be able to restrict access to a portion of your criminal record under the Indiana Second Chance Law. Check this out. In 2011, the Indiana General Assembly passed legislation permitting individuals to seal portions of their criminal record. This was revised and condensed into Indiana Code 35389 effective July 1st, 2013. Oh my God. If successful, any case that has been restricted will not show up on a criminal history check by a non-criminal justice organization or individuals. Criminal justice agencies like the court, the prosecutor, and police will continue to have access to all the information. Although it has been nicknamed an expungement law, Indiana's Second Chance Law only restricts access to criminal records. It does not forever erase or expunge one's criminal history. Petitioners filing under the Second Chance Law that were not convicted do not have to pay a filing fee when filing under the Second Chance Law. This shit's free. There are different classifications of individuals who may qualify to restrict access to criminal records pursuant to Indiana Code 35389. Expungement petition resources. To research your Marion County criminal case or arrest charges, you can use the public access terminals located in the self-service legal center located inside the community justice campus. You can also use the public access terminals inside room W122 in the Indianapolis City County building. The clerk's office is not in a position to provide you legal advice. If you decide to hire an attorney to help you with this process, the Indianapolis Bar Association offers a lawyer referral line. You may also contact pro bono agencies like Neighborhood Christian Legal Clinic or Legal Aid to ask if they are in a position to assist you. And check this out. Check this out. For those of you in the back who really want to be flabbergasted, okay? Excuse me. Those of you in the back, check this one out.
Bruh.
Individuals convicted of a violent or sexual felony. Check this out. You tell me if this is acceptable in a civilized society. Except as provided in subsection B, this section applies to a person convicted of a felony, including an elected official convicted of an offense while serving the official's term or as a candidate for public office, and a person convicted of a felony that resulted in serious bodily injury to another person. This section does not apply to the following: a sex or violent offender or a person convicted of an offense described in IC 3542.1, IC 3542.3.5, or IC 3542.4. Listen to this. At least 10 years after the completion of a person's sentence, including the completion of any term of supervised release and satisfaction of all other obligations placed on a person as part of that sentence, unless the prosecuting attorney consents in writing to an earlier period, the individual may petition the court to restrict access to records contained in a court's file, the files of any other person who provided treatment or services to the petitioning person under a court order that relates to the person's felony conviction. The court will order the conviction records to be restricted if there is convincing evidence that, one, the period required by this section has elapsed, there are no charges pending against the person does not have an existing or pending driver's license suspension, the person has successfully completed the person's sentence, including any term of supervised release, satisfied all of their obligations placed on the person as part of the sentence, the person has not been convicted of a crime within the previous 10 years, or the prosecuting attorney has consented in writing to the expungement of the person's criminal records. The court may order the conviction records described in subsection C as marked as expunged in accordance with section 7 of this chapter. So look at it, 10 years. Again, 10 years. Okay? Go back to cursage. Sorry about that. Almost clicked the wrong button. Remember, the original filings, right, that we looked at, (2012), 2003, 2002, 2002, child molest 2002, child molest 2012. (2021). Did 10 years elapse? 10 years, was this the catch here, that the 10 years had elapsed from the original date of filing? Because remember, this didn't pass into law until 2012 or 13, something like that. To be expected, many lies were told. Okay, many lies were told. It wasn't me. It wasn't me. It was someone else's social security number and a clerical error. No, the clerical error was this shit getting released. That was a clerical error. What was the other one? That little girl lied. That little girl lied. I don't know. I don't know. Help us by filling out reports on 4PITs and the prof. The more reports filed, the better chance their channels will be terminated. Oh, so we see, now we're getting to the MO here. What's the objective? What's the objective? Silencing of dissenting opinion, right? Silencing of skeptical voices. There's dozens of people out there watching your channel, including your own subs and followers. Hey, dickhead, what makes you think you're exempt from any policies or rules on YouTube or Substack? And for your information, jackass, I haven't filed anything on your YouTube channel since early last week, so you need to go fuck yourself. And for your information, there's at least 24 people that have been watching your channel and striking you to get you taken down as soon as possible because you're violating the rules and you know you are, and you think you can get away with it. It's not going to happen. You know, the funny thing about it is I don't even watch your shit. All the other people do, and they send me everything you're doing. So I advise you to take the shit out your mouth before you speak, because it's nothing but fucking idiotic shit coming out of your mouth. It's why your numbers are dropping and your views are dropping. And now you got your own people in your chat pissed off because they can't voice their own opinion on your channel without you fucking having conniption fit, sound like a little bitch. Have a nice day. By the Delulus are mass reporting on you. You don't realize there's about a dozen people going through every one of your videos and every one of your posts to find if there's photos, names, or anything like that being used without our consent. And we're filing, we will get your channels taken down. And besides that, we're going to go to your Substack also and file copyright strikes also. That channel's getting ready to get taken down also. Fuck around, find out. Frank Meister, why don't you tell everyone how you tried to convince me you had feelings for me, and after I didn't fall for it, and after I repeatedly told you I don't drink at all, you decided to invite me to come to Greenwood to go to a bar with you and your friends. So again, I told you I don't drink, and therefore I wouldn't go to a bar with you, and I don't put myself in situations I don't belong. I'm grown. So when I did not agree to get set up by you and Frosty in Greenwood, you had Snay and Jinx start saying stuff about you and me. You're an embarrassment to the crime community. You're almost a crime yourself in how you play the families. I can bet 199% bet you've never told them your bestest friends are the ones leaking. That would look bad to tell the victims' families that the people you get along with best are shit scumbags. You may think I'm a waste of life. I say ditto, bitch. Go back to wherever you came from before popping out of Marv's puss. I don't think I could have said it better. Anyhow, for those interested, I suggest you all go to my Substack. Deb, would you please post my Substack link here? I have a lot of information at my Substack since it was mentioned or referenced, including a litany of evidence that has been removed from YouTube. Because remember, they've weaponized the YouTube complaint system, as I've mentioned early in the show, so that all the evidence of this bad behavior has been removed from YouTube, including the threats to shoot and kill Richard Allen and being coddled by the Delphi Police Department in front of the courthouse. You guys remember that episode? Well, that thing in and of itself is, thank you, Deb, is right up on my Substack. You can go there to readtheprof.substack.com. I highly recommend you go to Substack and subscribe to me over there and get the paid membership if you'd like to support my work. Over there, there's a whole bunch of information and receipts, and there's still more coming. I regularly produce information that I'm not really safe or allowed to produce on YouTube because it's going to get fraudulently struck down. But if you go to my Substack, you can see a whole bunch of stuff, including videos, including the death threats, the announcement of hits on Richard Allen, the carrying of firearms, the all of the fraudulent privacy claims. And like I mentioned, I'm pretty sure like there will be an attempt to remove this content from YouTube, especially since it reveals 2 separate arrests for child molestation, one for criminal recklessness and one for violation of probationary terms due to the first arrest for child molestation. So I'm sure there will be an extreme effort to have this particular content or this live right here removed. So hopefully you download it. You can go to my case, as I mentioned, and search for the case yourself if you want to get the documents. I'm likely going to preserve a copy of this elsewhere in case it gets taken down, because we know the silencing of our voices is the #1 tactic, because there's not much else they can do. They cannot argue the facts or the truth of the case They cannot debate openly and let the best argument win. No, what they have to do is engage in these smear and silencing campaigns uh, to try to discredit, make people not listen, make people not look at the facts. I think that Mr. Wessling showed you the facts 2 years ago. We've shown you the facts tonight. My case is showing you the facts right now. If you go to my case, uh, there's no question anymore about what the record is. Now, whether or not it's going to be admitted to or allowed to stand, well, that's a whole other story. But you got to ask yourself, why is it that Indiana State Police, Hannah Shakespeare, in the documentary for the Richard Allen case, which I don't remember where that aired. Maybe it was on Hulu or something. Remember, this guy was featured in the Hannah Shakespeare documentary. He's regularly announced that he is a spokesperson for the Patty family. He's been an absolute disease and just coincidentally happens to use Vinlander green colors in his branding. Ask yourself a question, true crime community. Who else covering the Delphi murders has as part of their branding Vinlander green colors? Okay, there are two creators out here who openly display the Vinlander green as a prominent aspect of their branding. Just something to consider. Not sure it means anything. But this was Delphi, the CHOMO, details from the public court record. And I will remind you that all of this you heard tonight was absolutely 1000% from the public court record and from public social media records. Let there not be any question. All of this was obtained legally through the Indiana court record system, also known as My Case Indiana. All other material was obtained on the public post on YouTube and in public discords. And as I mentioned at the beginning of the show, I have personally redacted all publicly or public identifying information or personal identifying information, even that which the court did not redact. So I've gone beyond my due diligence to redact the personal identifying information. However, the court failed to do so. So if you go to my case, you will see that all for yourself. But I think what I'm saying here is we're done with the bullying. Okay, we're done with the bullying on YouTube because we choose to speak out about our concerns about our case. And it seems to me that all of this is being condoned by the Indiana State Police and Unified Command. Remember, you've seen this individual hugging up with the Patties. You've seen this individual hugging up with Jerry Holman, loudly announcing his intimate connections with law enforcement in Indiana and the court system in Indiana. So all I can assume is that we are dealing with confidential informants, of which this guy is one. And unfortunately, it seems like the Hannah Shakespeare documentary featured a couple confidential informants who loudly announced that it was their job to help them, to help law enforcement, that it was their job to help them with the case. And if you go watch that documentary, you'll see the two individuals I'm talking about. They're the only two who said that we help law enforcement. That's what they wanted us to do. I think we have a problem here in that we don't need confidential informants out here brutalizing people on social media. And if law enforcement is condoning that behavior, that needs to be addressed by the Supreme Court of the United States. I think it's a technique that law enforcement needs to be barred from using. You can use your confidential informants, but not to stifle public speech or criticism. And the fact that it appears that that's what's been happening is absolutely unacceptable. And the onus is on the federal government, and local and state governments to put an end to the terrorization of the general public and population uh, on behalf of law enforcement utilizing confidential informants. So, with that being said, that's the end of our show tonight. And I hope that it meant something to all of you. If you'd like a copy of any of these documents, please send me an email. You can find that in the link tree that is pinned at the top of the chat and also in my channel description. And as I mentioned, they're also easily available on My Case Indiana. So I want to thank everyone for being here, especially our donors tonight. Big shout out to MJ Lewis, 1964, Dennis McKean, 8773, Deb 731, Rebecca Ann, and Silenced Woman. Thank you all so much for the support tonight, and thank you all for going ahead and checking out my Substack. And for any of you watching, please hit the like on your way out and leave comments down below on the replays. We always appreciate hearing your input on the channel when the lives are finished. And in all the content on the channel, I love the comment section. Please leave us your comments. This is a highly concerning situation, in my opinion. Like, this has great implications for our society. If you have a case that was highly CI involved, you get 2 little children dead, and then for 9-10 years after the fact, you get a bunch of CIs orbiting around this case, terrorizing the community. This has great implications for society as a whole. And I think that a review needs to be had about the tactics of informants working for law enforcement and what they are allowed to do and what they're not allowed to do. And I'd like to point you all towards my last several live streams in which I covered some concerning things, especially the individual only known to us as the undercover trooper. Okay, in the case of Richard Allen, there was an individual tapped by the defense who was an Indiana State Police master trooper, referred to as the undercover trooper, who had infiltrated the Vinlanders and the American Guard and a bunch of the individuals who seemed to be surrounding this case, including the biker clubs. And this individual announced that part of his responsibilities was the coordination and recruitment of CIs. You know, so this individual, the undercover trooper, probably has a wealth of knowledge concerning all of these potential CIs who are tied into this case, including the ones terrorizing all of us on social media. So I look forward to the possible developments and hearing more from this undercover trooper and seeing if Richard Allen is granted the appeal, what may come in a new trial from that undercover trooper. And on separate news, I don't know how many of you have paid attention to the Letitia Stotch case here in Colorado, but her trial was just overturned, okay? And she was ordered to be retried or a new trial because of conflicts of interest with one of the jurors being related to the DA. And I've mentioned that although this issue was not raised in the trial of Richard Allen, we know that there are several conflicts of interest in the trial of Richard Allen that should have been raised, especially the relation by marriage of the prosecutor to one of the victims and the relation of one of the prosecutors, Stacy Diener, to the judge, the initial judge on the case, Benjamin Diener, who had recused himself. And then there are 2 additional potential conflicts of interest, which revolve around Kathy Shank and Keegan Klein, and that being both tied to Ron Logan, both the Kleins and the Shanks being intimately connected to Ron Logan, which in and of itself are is another conflict of interest, or two more. So that's four conflicts of interest at a minimum. And we don't know any of the identities of the jurors because none of them have had the balls to step forward here in the Delphi murders case. So we don't know whether or not there were conflicts of interest in the relations of the jurors. But that being said, it's highly concerning that when you had a case such as Letitia Stouch, who is absolutely, certainly guilty of the crime of the murder of that poor young child, the brutal, brutal murder, the slaughter of that child, a person who is definitely guilty of committing the crimes, for her entire trial to be overturned by the appellate court of Colorado for something as small as a conflict of interest with one of the jurors being related to the DA. I think there's a big, big, big cause for public outrage in the trial of Richard Allen, where we had all of these conflict of interests, as well as all of the legitimate appellate issues that were raised by the appellate attorneys for Richard Allen, Stacy Uliana, and Mark Lehman. The manifold appellate issues that were just egregious violations of his constitutional rights and his right to a fair trial and due process. And you combine that with the flimsiness of the case against Richard Allen, the almost complete lack of evidence on Richard Allen, the horrendous treatment of Richard Allen as a pretrial detainee, being kept 13 months in solitary confinement with ongoing mental health issues, deep psychosis, death threats, threats to his family, all of the things that happened with Richard Allen, the treatment by the malpractice medical treatment by the insane Dr. Monica Walla, who was an extreme, unhinged Delphi fangirl even prior to treating Richard Allen. There's so much. And then you add to that all of the conflicting witness statements, the refusal of Betsy Blair to identify Richard Allen, the refusal of any of the other witnesses to identify Richard Allen, the refusal of any of the, or the lack of any of the witnesses identifying Richard Allen as the individual they intended to portray in their police sketches that were produced, in which we know there were multiple of those, that many of which you haven't seen. All the conflicts in the witnesses, all the negligence or incompetence by law enforcement, the absolute flimsiness of the case, combined with all the conflicts of interest, and then the genuine appellate issues that were raised by Richard Allen's appellate attorneys. I think this is absolutely appalling. And if Letitia Stauch can get a new trial, why can't Richard Allen? Anyhow, thanks everyone for being here. I'll say goodbye to you on the way out, and please hit the like on the way out. Appreciate you being here, especially all of you new viewers. We love you new viewers, okay? There's a lot to look into with this case, so please do. All right. Well, thank you. I want to thank Deb, my main mod, Deb731. Thank you so much, Deb. Thank you, Digital, Matt Payton, Silent to Woman, Swade Smith, Monday, Fur Baby Daddy, Rebecca Ann, Four Pit Bulls Across America, Dennis McKean, Peggy O, Shane Wall, Who's Her Daddy, Christopher, apologize, it takes a while. Mustang, thanks for being here. Jamie Boyd, Dewey Ox, okay. Nicole Watt, Critter Mama, Daisy Ask, that's Amy G. Thank you, Amy G. Pertinent, Lowered Customs, Gaslight You. Oh, hey, Christina. Anyone else I've missed? I apologize for missing. Just let let me know down below. Becky, thanks for being here. Okay, David Rogers, Brenda Mays, everyone else. Matt Payton. Hey, God bless all of you, and God bless Libby and Abby. Okay, we'll see you later, and good night. Go subscribe to my Substack.
My heart is so cold, my energy is contagious. All the pain, I can't take it. I'm staying grounded and graceful, cause I know everything that I've been through only made me count my blessings daily. Yeah, they've been acting shady, but I don't take it personal. The memory's fading, I'm enjoying the moment. I've been smelling the roses, taking time to reflect, stepping back, the truth unfolding, unfolding. Got nothing to prove, cause I'm not the intentions are not pure. I can't let you get too close, cause I'm vibrating high. Ain't got time for your ego, these niggas quit to turn their back. Acting like the amigos, they never cared in the shows. Wasn't with you at your lows, assuming that you gonna fold. But baby, I've been growing ever since I let you go. And I've been doing better, and I know that hurts to know. Hurts to know. Only good vibes around me, and that's for sure.
Off some fucking terrorist, a fucking pedophile, sympathizing fucking terrorist.
Only need good vibes.
Fuck you. Fuck you. Fuck you.
This stuff's coming to a close. There are more than one person involved with this case. It's not just Richard Allen. There's several others, and we've all seen them on TV and been interviewed and spoken about way back in the beginning. Law enforcement has known about these people, but they have to methodically build a case.